Good morning, everyone, and welcome to the RTPI's annual Planning Law Update. My name is Gemma Jobling. I'm Director of JPE Planning and currently Vice Chair of the RTPI's Northern Ireland Executive Committee. I'll be chairing today's update, and I'm delighted to welcome our two speakers. Firstly, Mr. Andrew Ryan of TLT Solicitors, followed by Mr. William Orbinson, QC, who will be giving us a legal update on some of the planning cases over the last year. We will then have an opportunity for questions at the end. You can submit your questions through the chat button on the right hand side of your screen. So if I can just move to introduce our speakers. Firstly, we have Andrew Ryan. Andrew joined TLT in 2015 and is a planning and environmental lawyer in the firm's UK-wide planning team, heading up the Belfast practice. He's worked in Northern Ireland since 2006. And is recognised in both Chambers UK and the Legal 500 as a leading lawyer in planning, environment and clean energy. He has been involved in many of the most significant development projects in Northern Ireland over the last decade, including wind farms, regionally significant waste facilities, major residential and commercial developments, fuel storage facilities, electricity transmission infrastructure projects and various road schemes. Andrew has significant experience in the clean energy sector on the planning and regulatory aspects of energy generation projects and has advised on the development and funding of numerous solar, wind and AD and waste to energy projects. He advises clients on a variety of issues, including planning law compliance, environmental permits, grid connection, power purchase agreements and incentive schemes, to name a few. He has particular expertise in environmental impact assessment and habitat regulation assessment. Andrew also advises on enforcement proceedings, appeals, judicial reviews, proceedings in Northern Ireland relating to planning and environmental matters, and provides advocacy in planning appeals and magistrates court. He also regularly advises on environmental liability issues in real estate and M&A transactions across the UK, for example, in relation to contaminated land and environmental regulatory compliance. Before qualifying in 2003, Andrew previously worked in enforcement and regulatory roles in the Environment Agency in England with a background in environmental biology. He is a member of the Chartered Institute of Waste Management and UK Environmental Law Association. So I think you're certainly well placed, Andrew, to provide us with an update today. Then our second speaker will be Mr. William Orbinson, QC. As Northern Ireland's only senior counsel with an exclusive specialism in planning and related environmental law issues, William Orbinson, QC, spends his time providing the planning community with expert planning and environmental advice and appearing in major planning inquiries, development plan inquiries, independent examinations, planning appeals, enforcement appeals and other proceedings, judicial reviews and prosecutions. With more than a quarter of a century's specialist experience, he works in all spheres of development, including residential, commercial, conservation, retail, waste and energy. The sole Northern Ireland Associate of PEBA, the Specialist Planning Bar Association for Planning the Environment and Local Government, Mr. Orbinson is also the only Northern Irish Senior Counsel to have qualified as a legal associate of the Royal Town Planning Institute and to be an affiliate of the Irish Planning Institute. He is the author of the main Northern Ireland text on planning appeals, planning judicial review, planning policy, prematurity, enforcement and local government planning functions. Mr. Orbinson's planning and judicial review case summaries 1976 to 2016 and the 2018 and 2019 case summaries update draw on his extensive experience of appearing in the Judicial Review Court and have attracted praise from Lord Kerr and the Supreme Court. His planning appeals principles, the decision-taking approach of the Planning Appeals Commission, 5th edition, was published before lockdown. So again, I think we're very lucky today to have speakers who certainly have a breadth of knowledge, and I'm looking forward to hearing the update from this year. So without any further delay, I'm going to introduce Andrew Ryan. And again, just a reminder, if you have any questions while either Andrew or William is speaking, please feel free to submit questions during the session and we'll come to those at the end. Okay, Andrew, thank you. Go ahead.
Thanks very much, Gemma. After those lengthy introductions, we don't have much time left for the presentations, but I'll rattle on as quickly as I can. So this morning I'm doing a brief legal update, a few cases that hopefully will be of interest to you. Next slide, please. Unsurprisingly, there's not been a wealth of cases recently in Northern Ireland. So whilst we're speaking about a couple of local Northern Irish cases, I'm also going to look at a number of cases from over in England. And the reason I'm doing that is because the principles that come up in those have equal applicability in Northern Ireland, so should be of interest. So the cases that I'll be looking at, we'll be looking at some judicial interpretation on the function of the High Court in judicial review proceedings, a brief look at Aarhus cost protection rules, some more judicial words on the reasons given in council decisions and what is required in those circumstances. The old perennial favourite of appropriate assessment has come up again with a new case in that area. And then we're also looking at the slightly bigger picture. We'll be looking at the impact of the Paris Agreement on climate change on planning policy. So next slide, please. So this first case that I will look at concerned an appeal against an enforcement notice relating to a quarry outside Kirkcudbright on the Ards Peninsula. And whilst the council had accepted that it was a valid planning permission for a quarry dating back to 1967, the council was of a view that the processing of rock extracted from the quarry was unlawful, along with various infrastructure developments such as porta cabins, weighbridges, etc. So the first part of this appeal that was heard related specifically to the scope of the 67 permission, which simply described the development as one for quarrying purposes. The applicants in this judicial review contended, as had the council at the appeal, that this did not include processing of rock. They also claimed that the 1967 permission had been abandoned before quarrying was resurrected in 2017. Next slide. And the judge was, in his decision, was very impressed with the decision that had been produced by the Planning Appeals Commission. And he said, with impeccable self-direction, and it was McCloskey J, as he was at the time, to put it that way, Commissioner Roux noted that the construction of every planning permission is a matter of law to be determined by the relevant adjudicative agency. And following the principle in Ashford ex parte Shipway, where there is an ambiguity in the phraseology of a grant of planning permission, it is permissible to consider extrinsic material. In short, from this exercise, the Commissioner concluded that quarrying purposes, in this case, included processing. The Commissioner, in his faultless self-direction, also considered that the 67 permission must have arisen from the removal of permitted development rights in the area which had been granted originally under the 1944 General Interim Development Order. Although there was no documentary evidence of this, the judge saw Commissioner Roux's expertise in this matter as unimpeachable. He said, "This is not merely unchallenged by the applicant, it is also precisely the kind of issue belonging to the realm of the presumptive expertise of the PAC, which the court should properly recognise." The further issue that arose was whether the quarry had been abandoned. Under the long-standing principle established by the House of Lords in Pioneer Aggregates in 1984, planning permission cannot be extinguished by mere conduct. At the appeal, on the evidence before him, the Commissioner concluded that the 67 permission was not abandoned. At the JR, the residents' representative, a certain Mr. Gordon Duff, who I shall come back to later on, presented further evidence complaining that it demonstrated abandonment. After an adjournment of some months to allow Mr. Duff to present the evidence in a form acceptable to the judge, he nevertheless was unwilling to adjudicate on the evidence, noting that, as he said, this is a court of supervisory jurisdiction. The PAC is a judicialised body. It is trite that judicialised bodies decide cases on the basis of the evidence presented to them. The judge also stated that JR was very much the last resort and alternative remedies must be exhausted. In this case, he suggested that Mr. Duff present the further evidence to the council, and if the council took the view that abandonment had in fact occurred, it could issue further enforcement proceedings. And if not, then perhaps he could pursue further proceedings against the council. This case, I think, is noticeable because it emphasises the role of both the PAC and the court in adjudicating planning decisions. The fact that the court is willing to grant the PAC presumptive expertise is a measure of the regard that must be had to the Commission and its decision making, and that it is afforded a significant degree of expert judgment, subject always, of course, to the test of irrationality or Wednesbury unreasonableness that many of you might be familiar with. Also, the court is emphasising yet again that its job is not to step into the shoes of the decision maker. Next slide, please. So the next local case that I'm going to mention briefly is that of Rural Integrity Limited. Some of you will be familiar with the serial litigant in person, Gordon Duff, and the somewhere around 33 challenges that he has brought under Planning Policy Statement 21 relating to approvals for single houses in the countryside. The first of these cases, brought almost as a test case, was a challenge against the PAC, the details of which actually don't really matter at this point. Rather, the important issue relates to the use of cost protection mechanism in the Cost Protection Aarhus Convention Regulations 2013, as amended in 2017. Briefly, a successful applicant under these regulations can rely on a cost cap to limit their exposure to costs award if the case is unsuccessful. Mr. Duff brought his 33 challenges under the umbrella of a number of limited companies, of which he was a shareholder and director. The intention, presumably, was for Mr. Duff to avoid personal liability, which even with a cost cap could be significant. In a challenge brought to the Court of Appeal, the issue before the court was whether Mr. Duff could rely on the Aarhus regulations using the rural integrity companies. The court held that he could not. Under Rule 5, Order 5, Rule 6 of the Rules of the Court of Judicature, a body corporate may only begin or carry on proceedings through a solicitor. The court was firmly of the view that if it had been the intent of the rule makers that the right to bring proceedings was to be given to directors or shareholders as well as employees, the rule would have said so. Mr. Duff was invited to bring the challenge personally and apply for Aarhus cost protection for himself. He declined to do so. And with that, his run of court cases has seemingly, like many things this year, ground to a halt. Next slide, please. For the next case, we're going to go somewhat further afield to Legoland in Windsor. Merlin Entertainments, owner of Legoland amongst other attractions, had applied for planning permission for a holiday village at its site situated next to Windsor Park. Two grounds of challenge arose from this decision that are of note in this jurisdiction, as they are matters that often arise in judicial review challenges on these shores. The first of these was the familiar failure to provide adequate reasons, and the second was the perhaps even more familiar ground of failure to conduct an appropriate assessment under Article 6.3 of the Habitats Directive. Next slide. The reasons challenge arose on the basis of the Council's Planning Committee's decision to overturn the recommendation of the Planning Officer to refuse the application. The reasons for refusal were inappropriate development in the green belt and impact on significant trees within the development site. Notably, and related to the second ground of challenge, which I'll come to, there was no mention of impacts on protected habitats. Overturning the recommendation to refuse, the minutes of the Planning Committee meeting recorded a decision that, and I quote, amount to very special circumstances to clearly outweigh the harm to the green belt and other harm where the economic benefits which were given substantial weight, and that significant weight was given to changes to the parking and traffic arrangements, as well as to the creation of accommodation. Unpack that if you can. This decision was challenged on the basis that this short statement did not constitute sufficient and intelligible reasons. If this might sound familiar, you may recall the judgment in early 2019 in the Northern Ireland High Court in the case of Knox. In that case, a decision was made by the Planning Committee of Causeway Coast and Glens Council to overturn a recommendation to refuse an application for a single dwelling in the Giant's Causeway World Heritage Site. The decision was issued, to quote McCluskey, with 3 reasons which it elucidated briefly in a bullet point list made up of 29 words. In that case, the judge concluded that by an admittedly narrow margin, the decision was sufficient to avoid being quashed by the court. Both the Knox and the present Hudson case tread very similar ground. In Hudson, the court ruled that even in cases where there is no statutory duty to give reasons, at common law, a duty may be implied in order to meet the requirements of fairness. Quoting the Supreme Court in CPRE Kent versus Dover District Council from 2017, it should not be difficult for councils and their officers to identify cases which call for a formulated statement of reasons. Such decisions call for public explanation, not just because of their immediate impact, but also because they are likely to have lasting relevance for the application of policy in future cases. The court recognises that the Planning Committee is not bound by the recommendation of its professional planners, but the reasons given must be capable of articulation and open to public scrutiny. In Knox, the judge took into account that there had been considerable debate at the Planning Committee meeting, which, even though the JR applicant in that case was not present, was sufficiently ventilated in the meeting minutes and other documents to allow an interested party to understand the decision, even though it was admittedly bare bones. In the Hudson case, the court found that the resolution, along with the conditions imposed on the planning permission and an associated Section 106 planning agreement, were enough to properly elucidate the decision. That said, and again mirroring the Knox decision, the court emphasised that as a matter of better practice, adequate reasons should be set out in the minutes or an annex to them. So whilst Knox could be considered something of a precedent in this jurisdiction, in a relatively young and developing planning system since the transfer of planning powers in 2015, it's perhaps surprising that planning committees in somewhat more long-standing local authorities in England continue to make similar errors. What I think this emphasises is that planning authorities, and indeed planning applicants or objectors, must be constantly vigilant that lapses into legal error do not occur. As planning committees become increasingly confident in their ability to disagree with the recommendations of their planning team, I expect that this issue will rear its head again in the future. Next slide, please. So the other interesting element of this decision as it applies here in Northern Ireland is in relation to the appropriate assessment procedure that comes from Article 6.3 of the Habitats Directive. As many of you I expect are familiar, where a planning application is located in proximity to a European designated special area of conservation or a special protection area, the planning authority must undertake an appropriate assessment to determine whether the proposal is likely to have an adverse effect on the integrity of the site or its features. This is a minefield for litigation, as the assessment that is required must be of the highest scientific standard, and either a failure to undertake the assessment or the failure to carry it out properly has been the cause of many a quashing order in the JR court, both here and in Great Britain. Whilst the process has many parallels with the environmental impact assessment process, it is a separate statutory requirement that often applies in circumstances where an EIA is not required. If anything, the appropriate assessment process has, over the last few years, been seen as a more critical target for objectors or other third parties bringing JR proceedings, precisely because it is a more prescriptive process than EIA. Also in recent years, the courts have taken a more flexible approach to EIA challenges, noting that it is not a counsel of perfection. However, more recent decisions on the appropriate assessment process are indicating perhaps a willingness of the courts to also take a more flexible and pragmatic approach. The Legoland development was to be located adjacent to Windsor Forest and Great Park, SSI and Special Area of Conservation, designated primarily for its vintage oaks. As a consultee to the application, Natural England identified the need for a habitats assessment, and the environmental statement noted that the proposal would have an adverse impact on the SAC without mitigation. Mitigation was proposed to be set out in a construction and environmental management plan, although not specified precisely what that mitigation would be, and further details on impacts and mitigation were also set out in an arboricultural assessment. Natural England ultimately concluded that the proposal was fine, but subject to appropriate mitigation being secured. Next slide, please. So on the face of it, this is the sort of decision that would leave lawyers either rubbing their hands in glee or sinking into despair and checking their PI cover, depending on who they were advising. Prior to this decision and the Canterbury case in 2019, this would have seemed like a slam dunk for a quashing order. However, whilst by no means less rigorous, the courts are now clearly willing to take a more nuanced and pragmatic approach. It was some years ago that the court noted that habitats assessment was not supposed to be a legal obstacle course, and this line of thinking, much as with EIA before it, seems to be emerging for habitats assessment issues. This is perhaps in direct contrast to the situation in Ireland, where the courts have been taking a much more prescriptive approach to the directive, as has emerged in cases such as People Over Wind in 2018, which in particular noted that the need for appropriate assessment could not be screened out on the basis of proposed mitigation. As it is in the Hudson decision, the court concluded that whilst there was a failure to comply with the requirements of Article 6.3 as implemented in the English habitat regulations, ultimately the court had a discretion as to the remedy or relief it could apply. Normally this would be a quashing order, but an important consideration, as had been the case in the Canterbury decision in 2019, was whether the final decision reached to approve the development would have been any different if the correct process had been undertaken. Again, as in Canterbury, the court concluded that the comprehensive material in the environmental statement and further environmental information and the extensive consultation process meant that an assessment had been carried out that could be considered appropriate in the circumstances. It is worth bearing in mind that whilst there is an extensive guidance on the form of an appropriate assessment, it is not statutory in nature, and so ultimately planning authorities are in principle free to determine how they go about the process. That said, it would be a more foolhardy advisor than myself that would suggest the usual appropriate assessment process is substituted by something perhaps more nebulous. However, by the same token, in instances previously where a local authority might have been inclined to consent to a quashing order without a fight when an explicit appropriate assessment was not carried out, Perhaps in the future they will consider whether the law has been complied with in substance, but not in form. For the older members of the audience, and to misquote a certain deceased comedian, I've done all the right assessments, just not necessarily in the right order. Next slide, please. The final case in my segment before I pass the baton to Mr. Orbinson QC is a significant judgment of the English Court of Appeal. But rather unlike, I suppose, the somewhat reductive world of habitats assessments and the like, looks at the bigger picture. And by what I mean here is the real biggie that is climate change. Amongst a slew of other challenges, including Friends of the Earth, an application for judicial review was brought by Plan B Earth against the decision of the Secretary of State for Transport to approve the airport's national policy statement, which identified new runway capacity for the southeast of England, in short, recommending a new runway at Heathrow. There are a number of grounds of challenge, but in the short time that I have left, I'll focus on the grounds relating to the Paris Agreement, which you will probably be familiar with as the international agreement very recently abandoned by some former US president or other for limiting global temperature rises to below 2 degrees centigrade this century. Next slide, please. So in issuing the ANPS, the Secretary of State was advised that whilst he had to take account of the UK's Climate Change Act, it was not necessary to consider the Paris Agreement. However, under Section 5 of the English Planning Act 2008, it was a requirement that national policy statements, of which this was one, must state how government policy on climate change is taken into account. The court held that the Paris Agreement was part of government policy, and therefore explanation of how it was taken into account was required. Next slide, please. Further, Section 10.3 of the 2008 Act required sustainable development, including adaptation to and mitigation of climate change, to be taken into account. Again, the court held that the Paris Agreement was obviously material to that statutory duty and the only reasonable view open to the Secretary of State. Ouch. That said, it was not a requirement that the SOS was obliged to follow the agreement. Rather, as with so many reasons decisions in the courts, it just had to be an explicit part of the material issues to be put into the balance. Next slide, please. Another issue emerging from the policy was whether the Strategic Environmental Assessment Directive for the environmental assessment of plans and programmes had been complied with. Article 5.1 of the directive requires that where an environmental assessment is required under Article 3.1, an environmental report shall be prepared and the information to be given for this purpose is referred to in Annex 1. Annex 1E states that the environmental protection objectives established at international, community or member state level, which are relevant to the plan or programme, must be included along with the way those objectives and any environmental considerations have been taken into account during its preparation. The court in this case found that international objectives must include matters above EU or UK level, and again, somewhat scathingly, the Paris Agreement was obviously relevant. Next slide. So this is all very interesting from an English point of view and conceptually, but what relevance is this to Northern Ireland? Well, first off, the Court of Appeal decision has been appealed to the Supreme Court by Heathrow Airport, so we await to see the outcome of that. The hearing took place in October, so presumably a judgment will emerge soon. But back to Northern Ireland, looking at Section 1 of the 2011 Planning Act, when the department is formulating policy, it must exercise that function with the objective of furthering sustainable development and take account of any other matters which appear to it to be relevant. This, to my mind, has parallels with Section 10 of the English Planning Act and would suggest that the department is under a duty to take account of the Paris Agreement in formulating policy, where, of course, it is relevant. Next slide. So what about local councils? There is a general duty under Section 3 to keep under review the matters which may be expected to affect the development of its district or the planning of that development, including the potential impact of climate change. Ultimately, though, this seems to be one of those issues where, provided the relevant authority at least shows that it has had regard to the somewhat nebulous and broad aspirations of the Paris Agreement, that is likely in itself to discharge this duty. Next slide. So, in conclusion, whilst it has been something of a quiet year in the courts, particularly here in Northern Ireland, the appetite for planning-related challenges really has not gone away. As is so often the case, judgments in England have direct relevance to Northern Ireland, and yet again we are seeing common themes emerging in relation, for example, to the nature of decision making by planning authorities, the limits of judicial oversight in planning cases, a slight softening in the court's approach to the often vexed issue of Habitats Directive assessments, and the need for government departments to remember the big picture stuff. So I hope this was of interest, and I am of course happy to try and answer questions at the end or otherwise skillfully bat them over to William. And so without further ado, I now pass over to William for his presentation. Thank you very much for listening.
Thank you, Andrew. So if we could get the presentation up. Right, well, good morning, everyone, and Gemma, thank you for that glowing tribute earlier. Could hardly have been better had I written it myself. Today, what I want to do is to talk about one particular case of considerable note in Northern Ireland, one of the very few, it has to be said, over the last year or so, which is the Chinese consulate wall case in relation to the Malone Road premises. So if we go to the first slide then. Just as a general point, coronavirus has hit the workload of the courts very substantially, and as a result, I am really scraping the barrel in terms of the topics here. Next slide. The only case, apart from the one that Andrew has dealt with, that occurred to me as potentially good material for this talk was the Chinese wall case. So if we could go to the next slide just to see the content of this talk. I'm going to talk about that case, which is Belfast City Council and the Consul General, lessons from that case, and then the principles governing the use of injunctions and planning enforcement, really using the Chinese wall case as a springboard for that element of the talk. Next slide, please. Next slide. So this is a decision of Madam Justice McBride at the beginning of the year. We seem to have gone blank there. We go back. Yeah, thanks. Oh, disappeared. That's it. So there's an application by the council for an interim injunction against the Consul General to restrain her servants and agents from carrying out works for the erection of a perimeter wall at the Malone Road Consulate without the benefit of planning permission. And what is interesting about this case is that the Consul General did not recognise the jurisdiction of the court, taking a view that she had diplomatic immunity, as did the consulate. However, written submissions were made on her behalf, both by solicitors and by counsel. Next slide. So the background to this is the residence on the Malone Road itself and all structures within the site were listed. The site lies within a conservation area, and as a result, the conservation area protection for trees applied. There were various concerns about the impact on listed buildings, detrimental impact, not only on the listed buildings themselves, but on the conservation area. And then there was a concern about risk to street trees from the trenching operation, which was related to the construction of the wall. Next slide. I don't need to take you through the enforcement history in detail, but you can see provisional TPO, temporary stop notice, listed building enforcement notice, and then works in breach of the TSN and the listed building enforcement notice. So what then happens is that the council solicitors wrote to the Consul General solicitors advising of the intention to apply for an injunction. In response, they got a letter saying no, court lacks jurisdiction because of diplomatic immunity. And then there were some discussions which resulted in an agreement for no further works apart from removal of materials and some incidental planting. And then after that, it was noted that works were ongoing. Next slide, please. So as the council began to press for these works to stop, the Consul General Solicitors wrote seeking acknowledgement of diplomatic immunity, and the Council declined to give that acknowledgement. And it seems that it was that refusal to acknowledge diplomatic immunity which caused a breakdown in relations between the Council and the Consul General. So works then continued throughout the rest of June, and the Council then applied for an interim injunction to restrain the works. Next slide. So the matter comes before Madam Justice McBride, and without getting into the fine tuning of this, which is all very arcane and technical, she held that the court had no jurisdiction to grant the injunction against the Chinese state because of diplomatic immunity of the state. Also, that the court had no jurisdiction against the Consul General herself, personally as owner of the premises, basically because she wasn't the owner in any personal sense. The ownership was registered not in her name, but in the name of the Consulate General. So in the view of the judge, the premises either belonged to the Chinese state or were held by the Consul General on behalf of the Chinese state. Madam Justice McBride, however, found that there was nothing to prevent the court from hearing proceedings against the Consul General as occupier, provided that she herself did not enjoy diplomatic immunity, and that the works were acts commissioned by the Consul General on behalf of the Chinese state for security purposes, so were consular functions, or were incidental to her consular functions and or works of security. So either way, the Consul General herself enjoyed diplomatic immunity. So fundamentally, diplomatic immunity for the Chinese state, diplomatic immunity for the Consul General. Next slide, please. The court notably underlined the point that just because someone enjoys diplomatic immunity doesn't mean that they're not acting unlawfully, just that they're immune from the jurisdiction of the court. And went on to say, even if the court was wrong in relation to the analysis on diplomatic immunity, the court would have declined to exercise its discretion to grant relief for a number of reasons. The first reason was that under international law, the consulate itself and the person of the Consul General were inviolate. So enforcement proceedings could not be brought without consent from them. And it was absolutely clear that consent would not be forthcoming. Secondly, nothing in the Consul General's response to the date of the judgment suggested that the fact of an injunction being granted would ensure compliance, and in fact would discourage compliance in the view of the court, because it was the very refusal by the Council to acknowledge immunity that led to the agreement breaking down. Next slide, please. Thirdly, the works were carried out on behalf of the Chinese state, and therefore, in the view of the court, granting an injunction would hinder rather than assist diplomatic efforts to have the situation resolved. Then, on a pragmatic level, given that screening had been erected around the site and the premises themselves were inviolate, and that the stop notice permitted workmen to deliver materials, it would be very difficult, if not impossible, to prove that they were acting in breach of any injunction, so that enforcement even against the workmen would be virtually impossible, and therefore granting an injunction just so that it could be served on the workmen would be beating the air. And then finally, given the correspondence, it was, in the view of the court, highly unlikely that the Chinese state would waive immunity in the face of an injunction. So fundamentally, granting an injunction was essentially pointless. As a result, the court declined to grant an injunction, but, next slide, made a couple of fairly pointed observations. First thing, and I don't wholly understand this given what the court said in relation to enforcing against the workmen. Madam Justice McBride said the Council might want to give some thought to whether proceedings can or should be issued against the builders, which I assume means the building company who employed the workmen. I don't fully understand that, because it seems to me that if you can't enforce against the individual workman because of screening and because of the terms of the enforcement notice, the stop notice rather, how do you go to a higher level and enforce against the company which employed them? In any event, that was thrown out for the consideration of the council. But she also made this rather interesting point, which is described by one of the counsel in the case, as the nuclear option, which was that it was at least arguable that the works themselves were unlawful. So unless there was a satisfactory resolution between the parties, the Secretary of State for Foreign and Commonwealth Affairs could simply withdraw the right to use the premises for consular purposes, so that the right of the Chinese state to occupy the premises would terminate. And the court said, in the light of that nuclear option, it was important for the respondent, that is the Consul General, to engage in discussions with the council so that, quote, those serious consequences do not occur. It's not a matter of public record where those discussions, if any, now lie, but presumably there are discussions at some level to try to get the situation resolved. Next slide, please. So some lessons from BCC and the Consul General. Next slide. The key lesson, I suppose, is that planning authorities effectively cannot enforce against diplomatic premises or diplomats acting in their official capacity. That's probably not a great deal of a problem now. I think there are only two sets of consular premises with a physical presence at the moment in Northern Ireland. That's the American consulate and the Chinese consulate. But there may be more after the Brexit transition period ends, and they may well be in environmentally sensitive locations. It's not without significance, I think, that both existing consulates are in South Belfast in the Malone area. But the key thing, I suppose, to bear in mind about all this in broader terms is that the grant of an injunction is entirely within the discretion of the court, and the court will not act in vain, will not beat the air, to use that phrase that Madam Justice McBride used. So there does need to be a reasonable prospect of an injunction proving effective. Next slide. So what I want to talk about now then is general principles governing the use of injunctions in planning enforcement, because it seemed to me that this is a largely underused remedy, and it is important to think about the implications not only of the Chinese wall case, but also of lessons that can be learned and principles that can be applied so that this remedy can be used more widely. Next slide. So, policy context for all this. The SPPS is silent on the use of injunctions in planning enforcement cases. PPS 9 has been revoked, but the English National Planning Policy Guidance states, what's set out there, I'll just draw your attention to the underlined bit. The local planning authority should generally only apply for an injunction as a last resort, and only if there have been persistent breaches of planning control over a long period and/or other enforcement options have been or would be ineffective. I stress that that is a policy position, but it appears to be the only substantive policy position which is of relevance in Northern Ireland. Next slide, please. So, looking then at the principles governing the use of injunctions, the relevant provision is section 156 of the Act, and it allows a council to apply for an injunction to restrain any actual or apprehended breach of planning controls where it considers that necessary or expedient. Now, whether applying for an injunction is necessary or expedient is a matter for the judgment of the council, subject to a challenge on public law grounds, Wednesbury unreasonableness, and so on. In making that decision, the council must take into account all relevant considerations, including whether an injunction is proportionate to the breach of planning controls in question, given, of course, that if an injunction is breached, the ultimate enforcement is imprisonment for contempt of court, so it's a pretty radical tool. The Council must also consider whether applying for an injunction is a necessary and proportionate response in human rights terms. And that's because nearly always applying for an injunction will engage Article 1 of Protocol 1 to the European Convention on Human Rights, which is protection of property rights, and or Article 8 of the Convention, which is protection of private and family life. And that was underlined by the House of Lords in South Bucks and Porter. The Council must also consider whether applying for an injunction is a breach of equality standards. And that is something that often comes up in the context of the travelling community, for example, where there can be disproportionate impacts. Next slide, please. Worth noting that what happened in the BCC case was that the Council sought an injunction after taking various enforcement options. But Section 156 allows a Council to apply for an injunction whether or not it has exercised or is proposing to exercise any of its other enforcement powers. So in principle, seeking an injunction is not necessarily a last resort in statutory terms. I drew your attention earlier to the NPPG policy statement, which seems to cut across that. There is, I think, a bit of a tension here between what the Council is entitled in statutory terms to do and whether the court is prepared in response to that to grant an injunction. But whether an injunction is granted and the nature of any injunction granted really lies in the jurisdiction of the court. And the court has to be satisfied that in all the circumstances, it is just to grant the injunction which is sought. Some factors pointing strongly to the grant of an injunction. Firstly, and probably primarily, nothing short of the injunction will provide effective restraint on the breach of planning controls. Second, a history of unsuccessful enforcement and persistent non-compliance. Thirdly, evidence that the respondent has played the system by willfully exploiting really every opportunity for prevarication and delay. And I have to say, having dealt with many enforcement cases over the years, that is definitely a factor in great many cases where you see people just spinning things out, taking any opportunity they can, perfectly legitimately from their point of view, and using appeal mechanisms and so on to keep operating in breach of planning control. But if there's clear evidence that that's what's being done, then that is a factor pointing strongly towards the grant of an injunction. Next slide, please. Other relevant factors include, similar to the factors that should be in the Council's mind when deciding to apply, human rights considerations, equality considerations, and the economic impact of either granting or refusing an injunction. Notably, it's not necessary to get an injunction to demonstrate nuisance or irreparable harm. But obviously, if there is harm, the degree of any harm will be relevant to the determination of the court. An interesting point is that an injunction can be used to prevent a breach extending to other land in the future or the intensification of breach, because it applies to not only actual but apprehended breaches of planning control. A common manoeuvre by someone on the receiving end of enforcement action is to apply for planning permission. And of course, we know that that can take some considerable time to resolve, and there can be appeal mechanisms, potentially judicial reviews, et cetera. But the principle is that an undetermined planning application does not necessarily prevent an injunction being granted. It is something that the court will consider, will take into account in reaching a balanced view on the matter, but it's not the be-all and end-all. And then the final point on that page is that an injunction can be made against persons unknown. This is the South Cambridgeshire case, where I think this involved a tarmacking operation by persons unknown, and the court was prepared to grant an injunction and effected service by nailing, not the court, but the officers nailing plastic bags containing the court documents to posts positioned prominently within the site. Next slide, please. Just a few thoughts on interim injunctions. In urgent cases, you can apply for an interim injunction pending the hearing of an application for a permanent injunction. And if possible, that should be made on notice to the affected party. If that's not possible, it should be explained to the court why it's not possible. One example of an interim injunction is an interim injunction to restrain a breach of planning control pending the outcome of enforcement action, the Runnymede case. Now that may seem a little counterintuitive, but it is permissible in principle. So you can apply for an interim injunction on the basis that something needs stopped now while enforcement mechanisms are applied. Applications for interim injunctions are decided on the American cyanamide principles. In essence, the court will consider whether there's a serious question to be tried and fundamentally whether the balance of convenience and the balance of harm favour granting or refusing an injunction. An interesting and practically important point is that normally when one applies for an interim injunction, one is asked for a cross undertaking in damages to compensate the recipient of the injunction if at the end of the day they're proved to be in the right. And that is something that is not normally sought from a public authority seeking to enforce planning law, the Kirklees principle. Next slide, please. So to conclude, next slide. This is an underused enforcement tool. It's complex, it's difficult, but it is useful unless you run into something rather arcane like diplomatic immunity. Thank you.
Thank you, William and Andrew. That was very helpful. There's a lot to get through there. I think certainly, William, you mentioned that the courts have had a bit of a light year, obviously, in terms of COVID. Does that mean that there have been less cases happening, or that we have a long backlog of cases? So is 2021 going to be a busy year? Do we need to set aside more time for the law update next year?
Well, interesting question. The last time I did this talk, I had probably 15 to 20 cases to pick from within a year. And as a result, it was quite a complex talk. This year, very few cases have come before the courts, especially since lockdown. Now, there's starting to be one or two coming through. I'm involved in a couple of major judicial reviews that are in the process of being launched as we speak. So what I anticipate is that come next year, there will be a lot more to deal with. COVID was really a shock to the system, and effectively the courts shut down for quite a long period of time. And it's only quite recently that the JR court has started to operate in a full sense again, albeit mostly virtually, which is fine, no problem with that. But it will take a while for it to get back into full running order in terms of volume, I think. I think it's also worth noting that judicial reviews in the planning sphere tend to be generated by economic activity of one type or another. So if the economy is locked down, it's not surprising that planning applications don't get pushed forward and the judicial reviews don't emerge.
Thank you. Andrew, you've probably had similar experiences, have you, over the last year?
Yes, indeed. I mean, I suppose just by kind of measure of the time that's being taken for judicial reviews to be processed now, we lodged judicial review proceedings. It was the week after lockdown, and we're getting a leave hearing on that case in the middle of December. So I think that sort of illustrates the sort of time periods that have now been involved. But it does seem that as the courts get back on their feet, that the backlog will be worked through. And yeah, I mean, one of the I don't know whether William's had any experience of this, but one of the areas that I was perhaps anticipating some challenges to come out of was the fact that the councils were dealing with planning committee meetings online and in sort of different formats to what they were used to, and whether that would lead to some procedural errors. But at least from my experience, generally, it seems the council's got to grips with the situation very quickly, and those sort of things didn't arise, which, you know, is certainly welcome from a developer's point of view. But yeah, I mean, judicial review isn't going away, and I'm sure there's cases in there just waiting to you know, pop out at the last minute, as they have a habit of doing.
Yeah, that's certainly my experience as well.
Thank you. Well, while we're waiting on some questions coming through, and again, just a reminder, if anybody has any questions, please feel free to submit them through the dashboard there. You can submit questions. There's a couple of points, I suppose, that come to light, and I'm sure we have quite a few members from the local authority in the audience. So Andrew, you had talked about the Knox case alongside others, and about, I suppose, the risks associated with given planning reasons, particularly where a council committee may overturn the planning officer's recommendation. I would imagine there's a lot of people in the audience would like to know, well, how can the planning committee ensure their decisions are more robust? You mentioned that Judge McCluskey had commented on the number of words and the number of bullet points in the Knox case, and by the just about was enough to justify the decision. Is there any lessons coming out of that in terms of how the councils might be able to just protect themselves in their decisions moving forward, or is it just essentially to ensure that the decisions are debated at length and that's recorded? Appreciate your thoughts on that.
Yeah, I mean, I think that, I mean, from the council's point of view, you know, the good news is that the Knox decision, which has been emphasised by the recent Hunter case, is that the bar for the level of detail in the reasons has been set relatively low, although albeit that the councils are encouraged to provide more detail. So the key thing really is, yes, to be safe, the more detail that can be provided in those reasons, the better. Sometimes I appreciate that's difficult because the decisions are sort of made there and then in the planning committee. But if it's on the back of a fairly robust debate and the reasons are clear, and also have you know, the other important point in all of this is not just that the reasons are clear and easily understood, but they do actually have a planning purpose and are related to material consideration. So that's the other key point. So I think it's something to be wary of, but it's not like there's this kind of gold standard that has to be ascribed to. But as with all these things, play it safe, precautionary approach. The more detail and the clearer the reasons, though, they are, the better and the more robust they're going to be.
Thank you, Andrew. And William, you made some interesting points, both about, I certainly found the points about injunctions and the use of injunctions very interesting. And I suppose while the Chinese wall case that you mentioned and the diplomatic immunity arising from that is rather unusual, I think it does reinforce the importance of the role of all parties in terms of the use of land and enforcement actions. And I just wonder, it sort of brought to light a question in my mind about the use of injunctions. Would it be appropriate, because I know there's been examples of this, where you may have a landowner and a land operator, and the operator may have an established lease on the land, and where perhaps the operator might be undertaking an unlawful activity that's then subject to an enforcement notice by virtue of the breach of planning, but perhaps the landowner is in a position where they would like to comply but are somehow prohibited from doing that because a lease is in place. Is that a sort of example where an injunction might be used? Or I've been aware of a few cases like that, and it can leave a landowner in a very difficult position where they have to take the operator through the courts because of a lease being in place if they aren't willing to engage with the planners on the enforcement notice.
Do you have in mind an injunction being sought by the planners or the landlord?
Well, I suppose either or, really, William. I just wonder, is that because I suppose the use of injunctions is something that's, as you say, is quite unusual, and we haven't really seen too much of it in the Northern Ireland planning context. I'm trying to just understand instances where it might be used, and I wonder whether that's one such instance. whether it be through the planning authority to limit the activity extended any further within the landowner's property, or perhaps it is something that the landowner could take out against the operator of the land.
Well, certainly I think the planning authority could use its powers to seek an injunction in those circumstances. Different considerations apply in relation to the landlord, because really the discussion that I had earlier on, the presentation was really dealing with the enforcement of public law mechanisms. And it's not really for private parties to do that. And I don't think if you tried, you'd get very far with our courts. There are mechanisms such as a relator action involving the Attorney General, where the Attorney General would take over formally an injunction application. But I just can't imagine our Attorney General being too enthused about being dragged into planning disputes. So any application for an injunction by the landlord would really be a matter of private landlord and tenant law, and would be subject to different considerations. It really would be a question of fundamentally breach of the agreement between the two of them. But in principle, yes, that would be possible.
Okay, it's an interesting one. Not that there's a case that comes to mind, but it's just popped into my mind there. A few years ago, I remember coming across a case that sort of triggered a thought in me. I don't know, Andrew, if you have any comments on that?
No, to be honest, I completely agree with what William's saying there.
Well, I suppose one more question. This one's for you, Andrew. You mentioned the Paris Agreement and Paris Climate Change Agreement, and in terms of English law, that has to be taken into national policy, and the same appears to be the case in Northern Ireland. Would that also have, I suppose, an impact on the local councils in their preparation of the local development plans then, because essentially that's the policy for the region?
Yes, I mean, it's a good question. I think, I think it would, and if you sort of filter down the principles that were set out in the decision in the Heathrow case, and again, I mean, this is subject to whatever the Supreme Court might have to say about it, then yes, I mean, I think arguably it's something that has to be reflected both in the sort of the setup of the plan and the strategic environmental assessment that goes along with it. But I suppose, the point, it seems to me, from that case is that it was quite a sort of binary issue. The fact of the matter was that the Secretary of State was told they didn't have to have regard to it, so it wasn't mentioned. And if it had just been filtered in a matter of paragraphs that they'd had consideration of it, that would have been sufficient. So again, it's not a difficult, it's not necessarily a difficult issue to build in to those plans and the assessment of them, but it arguably is a sort of necessary facet of them.
Okay, thank you. Well, that's all the questions we have, unless there's any last minute ones coming through, but at the minute I don't think there are. It's been certainly very interesting hearing the update from both of you. I don't think we'll hear another Chinese wall case in the next couple of years, William. You might have trumped everybody. I shouldn't use that word, but this year around. But certainly looking forward to next year's law conference or law update. I would imagine there'll be quite a few cases coming through. And I'd like to take this opportunity on behalf of the RTPI to both of you for speaking today. It's been very helpful. We'll all go away and lodge those cases in our mind and try and refer to them moving forward. So I might just finish up today and thank everybody for attending. And once again, thank the speakers, both to William and Andrew. Okay, thank you, everybody.
Thank you.